Hello, good afternoon. My name is Sam Kareem, and thank you for joining Quarter Protection experts from King's Chambers and Price Slater Gorn for this webinar on Practical Guide to Quarter Protection Applications for Personal Injury and Clinical Negligence Lawyers. The webinar, I hope, will provide a step-by-step guidance on how to apply to the Quarter Protection to manage someone's funds, when applications to the Quarter Protection are needed, to authorize care provisions and arrangements, and how to obtain evidence on someone's capacity, for instance, and finally, the authority of a property and affairs deputy. So who better to discuss all of these issues than my very, very talented panel to this afternoon. They include Tom Young, who is a solicitor at Price Slater Gorn, and he's the head of the Quarter Protection Department there. He's a wealth of experience in all aspects of Quarter Protection work and is often involved in providing evidence to the Quarter Protection on costs in litigation cases. Secondly, Francesca Gardner is a leading specialist in all areas of mental capacity and mental health law at King's Chambers. Her practice encompasses all aspects of Quarter Protection work, and her practice is unique insofar as that she practices in health and welfare and property and affairs. Her property and affairs practice involves advising on issues relating to the scope and the role of financial deputies, power of attorneys, statute wills, and financial abuse. Jade Price, who's going to be part of our first video this afternoon, but she is a trainee solicitor at the Quarter Protection Department of Price Slater Gorn. She's involved again in all aspects of Quarter Protection work, in particular on professional deputy matters on behalf of her firm and the corporation, and having held roles with the firm's clinical negligence department and personal injury departments, she's obviously well versed to face issues raised by lawyers in both areas of work. And finally, by no means least, Ariana Kelly, who's also a leading specialist in mental capacity, community care, and mental health law and inquests at King's Chambers. Ariana acts in all aspects of Quarter Protection matters, including health and welfare, property and affairs, and serious medical treatment. And she's both on the Attorney General's Regional Panel of Counsel and the Equality and Human Rights Commission Panel of Counsel also. So, welcome to my panelists. It's great to have you here. We've divided this afternoon into various slots. Sadly, Faye Collinson, who is going to be talking about security bonds and other ways of protecting people, can't be with us for personal reasons, but I'm told that her slides will be available at some stage for distribution. In terms of today's arrangements, please use the chat function in the Zoom bottom left-hand corner for any questions, and we anticipate that we'll be taking some questions and providing some answers, hopefully, just after Tom's first part of his talk, and then we'll go into the remainder of the seminar. So without further ado, I'm just going to load the video, so bear with me because my technological abilities can be wanting sometimes, but I hope on this occasion it's not.
Hello, my name is Thomas Young and I'm a solicitor at Price Slater Gorn, and welcome to this session on the Quarter Protection from the perspective of personal injury and clinical negligence cases. I'll be assisted by my colleague Jade Price, who should also be able to see on this video. It's a session that we would normally conduct in person, which means it's slightly less interactive than it would be ordinarily. However, we do have the benefit, obviously, you can sit there in your pants and watch it, which is quite nice for some of us. And we'll try and use the technology to the best of my ability anyway, to try and make it interactive in terms of asking questions, which I understand is possible as we go along. Also, obviously, we're happy to set up queries if anyone wants to discuss a particular case afterwards, whether that be via email or through the phone. So we'll try and make it as interactive as we can within the parameters of this, and hope that one day in the future we will actually be able to all meet up in person. So what I will do now is I'll try and share the slides. So if you just bear with me one moment. So just a brief overview of who we are. We're a Quarter Protection team. We specialise in financial deputyship cases. Price Slater Gorn, we believe we've got a fresh approach to this. We we're competitive on the pricing and the services we offer. We strive to be the best. The approach to much of this is really that the key is the relationship with the clients. And what we hope we can do today is talk you through a little bit of what we do in terms of deputyship and the issues that we see arise on the cases where there's ongoing litigation claims or cases where it's towards the end of settlement and sometimes they come to us. So we will start by a brief introduction to the Mental Capacity Act and the Court of Protection. Now, the Court of Protection has jurisdiction to deal with all issues relating to mental capacity. It was established by the Mental Capacity Act, and it's a relatively new area of work compared to other fields such as property and clinical negligence, which are much longer and have been around for a longer period of time and people are more familiar with in certain cases. The court has jurisdiction to deal with, say, all issues around mental capacity, which includes both financial issues and welfare decisions. And that's sometimes relevant. Whilst we today are going to focus on the financial aspects of the court protection, the fact that the court also has jurisdiction to deal with welfare issues is sometimes relevant when we look at what the court might consider to be urgent. And quite often the issues around welfare do tend to be considered ahead of financial issues for obvious reasons. If it concerns life-sustaining treatment or a complex welfare issue, then that's likely to be more significant and more likely to be heard ahead of a case that deals with financial issues, which I say is relevant sometimes when we find ourselves in a situation where we need to deal with something quickly that relates to finances, but we find that the delays with the court protection might work against us. So I think that's an important point just to raise at this stage, and we'll deal with that as we deal with time limits for applications as we go through the presentation. But I think that's just always important to keep in mind when sometimes we find ourselves answering queries as to why a court isn't dealing with something quicker or why it's not being considered as priority. Now, within that, obviously, there are certain cases where financial issues can be very urgent, where there's safeguarding, but I just mean in terms of the broader sphere of what the court protection are dealing with, it can be that the welfare decisions are sometimes dealt with more quickly. Now, the principles of excellent capacity and the Mental Capacity Act are the same with both financial issues and welfare decisions, but we often see that the way in which they're implemented sometimes is different, and some of the procedural elements are also slightly different when it comes to looking at financial issues. So, for instance, financial applications are commonly determined on the papers, unless there's a contentious issue or something that's a little bit more unusual. Whereas I think welfare issues do tend to involve more attended hearings, whether that be over the telephone or in person at the court. The Office of the Public Guardian, they supervise all financial deputyships, and they're also able to bring applications to the Court of Protection themselves. Unfortunately, we've seen an increase in the number of applications that have been brought by the Office of the Public Guardian, which is a result of, I suppose, it's two elements. There might be an element of increased financial abuse, unfortunately, but they are also being much more proactive in the way that they're looking at cases and the way that they're investigating deputyships, which is why it's so important that the deputyship is put in place appropriately and that there's a suitable candidate in place and that are aware of the duties and aware of the requirements under the Mental Capacity Act and the Court Protection. The central court for the court is located in London, but the regional courts can hear cases. And again, what we're seeing is the courts developed over time, the regional courts are picking up more of these cases. To start with, that was more of the welfare work that stemmed from the deprivation of liberty cases and an influx of work following the Cheshire West decision. But even with the financial decisions, we're seeing that more of these are now being dealt with at regional courts, which is assisting with cases moving forward more quickly. In certain circumstances, it means that we've got judges that are less familiar with court protection, but I think in the long term, it is a positive route. So if we move on to the next slide, so that's a very brief overview of the mental capacity and court protection. Now, powers of the court protection in terms of financial decisions, the court can determine whether or not someone has capacity to make a decision. So if we think about the jurisdiction of the court protection being around issues of mental capacity, the first point we always need to think about is whether or not the person in question has or lacks capacity. And where there's a dispute around this, the court of protection actually has jurisdiction to determine the point. So it's not just making decisions on behalf of someone who lacks capacity. The court can also pick up disputes, or if there's uncertainty around assessments and different opinions that requires someone to step in and look at what the actual position is in order to progress a decision, it's the Court of Protection as jurisdiction to deal with that. Now, the appointment of a deputy, which will be a large part of what we talk about today, is something that the court can determine. That can be for financial decisions, as we're mostly speaking about today, but it can also be for welfare issues, although that is, as we see it, less common, because the overriding principles of the Mental Capacity Act and the Court of Protection are the assumption of capacity, which I suppose goes back to that first point on the court being able to determine whether or not someone has capacity. The principle that someone must be supported to try and make a decision, which ties into capacity, and not just if there's an issue around capacity, then it doesn't always necessarily immediately flow that the person lacks capacity. Similarly, that if someone makes unwise decisions, that doesn't automatically mean that they lack capacity. And then there's the best interest principles, that any decision that's made on behalf of someone under the Court of Protection and the Mental Capacity Act must be made in their best interests. That only follows if it's been determined that they lack capacity. And then finally, that any decision must be made in the least restrictive way, which ties back into the point I've just made about welfare deputy appointments and financial deputy appointments. Now, the reason that we see less welfare deputy appointments is because of that final point, and the fact that the court in most cases believes that that's a very restrictive step, as opposed to financial decisions that someone needs to make on a day-to-day basis. The appointment of a deputy to deal with that on the person's behalf in many ways is the least restrictive route, because it enables the flowing of those decisions and for the person to get on with their day-to-day life with someone there with the authority to act on their behalf. The court also deals with one-off financial decisions. So we'll go into a little bit more detail about the role and the duties and the powers of a deputy, but there's often a requirement for one-off financial applications that might deal with a particular decision, such as purchasing a property, making a gift, pursuing litigation on behalf of someone, which would be separate to litigation claim that might be around things like an EHCP or an appeal against a care decision. So those one-off financial decisions, they can be aside from the deputyship, or they can be made by the deputy. And the Court of Protection also has jurisdiction around financials to revoke or remove an attorney. Now this is an important point to keep in mind very early on in a case where there might be an attorney appointed. There could be a breakdown in relationship. It might be that the attorney is not appropriate to act. There's various reasons why, if someone later lacks capacity, you might want to look at the issue of whether or not the LPA, or previously the EPA, was actually validly made. And we'll turn to that, the case of SAD and ACD versus SED, a case that I was directly involved with. And I won't go into the details of that case, but the point I want to make is it's important to think about these potential issues early on, whether that be that a one-off application might be needed to be included as part of a deputy appointment or separately from a deputy appointment, or if there's issues around the suitability of an attorney, whether or not that requires the involvement of the Court of Protection, because the issue is with this, there's significant delays when it comes to making these applications. The court won't deal with these overnight unless there's significant urgency or safeguarding issues. And with the point of urgency, I go back to that issue around, we have to think about urgency within the sphere of what the Court of Protection is dealing with. So just because it might be an inconvenience or causes a problem, that doesn't necessarily follow that the court would determine that it's actually an urgent case for them to consider. Now, in the case I've mentioned there of SED, that actually took around 18 months to 2 years to resolve, which is why I mentioned that it's very important to think about these issues at a very early stage, so that the Court of Protection solicitor involved or the litigator dealing with the claim can think about how it's going to tie in with the claim and can take steps to progress and deal with that at an early stage. And when it comes to powers and financial decisions, the one final point I want to make on this slide is the statutory will. And again, without going into the detail of this, I just want to make the point that the test for capacity around this does vary from the test around mental capacity under the Mental Capacity Act, and it's a different threshold. So where we've got clients that might lack capacity to manage their finances, going back to the point about the assumption capacity and be able to support decision, it doesn't always necessarily follow that they would necessarily lack capacity to make a will, which is important, again, when we think about the claim, whether or not we're going to need to incorporate the cost for a statutory will within the claim, whether or not there's work that solicitors acting on the case can do with the client prior to settlement around a will and making sure that their affairs are in order if they have capacity. So again, the key point on this is the presumption of the capacity, and not assuming that someone lacks capacity because of any particular issues that they encounter, or any aspects of their needs that arise from the case. Okay, so the appointment of deputy for property financial affairs, and this is what we predominantly deal with at Price Later Gordon Solicitors. This is the key focal point of the talk today. This is what often is an important element of a litigation claim, and we want to give a broad overview of the process, the points that we often consider and that arise in cases that we're involved with. And the point of that today really is not to go into the details of that, because as personal injury or clinical negligence solicitors, you're not likely to be directly involved. It's to try and give a flavour as to what's involved from our perspective, and some of the things that you can be thinking about when you're progressing a claim and you might want to seek advice from a court of protection solicitor. So as I say, that the Court of Protection can appoint a deputy for property and finances on behalf of someone who's been determined to lack capacity to make decisions for themselves. Now, the order appointing the deputy will set out the scope and limits on the powers of the deputy. And there's certain things that a deputy can never do. They can't get involved in decisions around parental responsibility or issues around the Mental Health Act. But as well as that, within the order appointing the deputy, there's likely to be additional restrictions on the power, things that will limit the scope around things that could be such as the purchase of property, seeking investment advice, making gifts. And whilst there's common threads with a deputy order, there's no two orders that are exactly the same. So it's important when you seek the involvement of a court of protection solicitor, and I'd stress that it's important to do this as early as possible, to highlight any potential issues in the claim that might be particularly relevant, because it's also possible to include in the application for the appointment of a deputy seeking particular authorities to try and avoid those restrictions, or perhaps have a separate order that might assist. And when we think of the time frame for deputyship, which can take around 6 to 8 months, possibly longer in certain cases, and there's a vast amount of uncertainty at the moment with the court given everything that's happened with COVID, it's very important to think about these issues early on. Now, the Court of Protection generally has jurisdiction to deal with issues around adults, but one of the exceptions to this is the appointment of deputy, where there's evidence to show that a minor will, on the balance of probabilities, lack capacity as an adult, and there might be finances that require management, such as from a litigation claim, whether it be an interim payment or a settlement. The court can actually appoint a deputy for a minor. And as I said there in the slide, this is often in cases where there is a litigation claim. I don't think I've come across any of these cases that were separate from litigation. And the issue with this that's really important is the issue of capacity. And Jade will probably support me on this. One of the things we often see is that these capacity assessments are sometimes the most difficult, because we've got a young child that might have the potential for future progress, can develop, especially when we're looking to implement care and support packages and therapies that might assist with that. And it can be very difficult for experts to commit to an opinion around capacity at this point in time. Now what we tend to say is, if the evidence isn't clear and it's not appropriate to pursue court protection at this stage, then there's obviously the personal injury trust that's open as a route. That is its own area and sits aside from this presentation. It's something that we can assist with, and there's a number of issues that have to be carefully considered in that, in terms of who the trustees would be and who's suitable to act. Similar as we would with deputyship, although there's slightly different requirements, but that would require the input of the High Court in terms of approving that trust. Now, with deputyship, the process is different. It requires an application to the court protection. And one of the things that can assist with this case is that the deputy appointment doesn't need to be without a time limit on it. It can be put in place that the deputy is under an obligation to continue review and consider the issue of capacity anyway. But if concern about the potential for future progress and changes, the order itself can actually put in a time limit as to when it will need to be considered again. And what we'd say to litigation solicitors and those involved in the capacity assessment is to really think about what their opinion is at this point in time on the balance of probabilities, And that's really important to make sure that it's going down the appropriate route, whether that be the personal injury trust route or a court of protection route with a time limit on it that will be reviewed again in a certain point in the future, or that there's sufficient evidence there at that point in time, and that the deputy will just have to continue to keep that under review. But it's really important that that's carefully considered in the instruction to the expert, because unfortunately we have seen reports where I think the expert, because whilst they'll be familiar with all the issues around mental capacity, they might not always be familiar with dealing with it where it involves a minor. And it can be really important the letter instruction really sets out what we require at that point in time, which in turn will have a knock-on impact in terms of the future costs and certain aspects of heads of loss with the litigation claim. The court can also decide whether or not a proposed deputy is reliable and trustworthy, and this is a key point about whether or not the person being put forward is appropriate. And the next point on this slide, I've mentioned that with the majority of cases considered by the Court of Protection, the most likely appointed deputy is a family member or friend or someone who knows the person. But when it comes to litigation cases, it's actually more common from our experience, and it's preferred in many cases by the Court of Protection, that a professional deputy is appointed. And the reason for that is that these cases tend to be more complex, where you've got the recruitment and employment of support workers, where you've got large sums of money that require investment, where you've got additional safeguarding risks. And it's not just safeguarding risks, it's burden on the family members or on the person that's appointed, it's additional burden. And if it's part of the litigation claim, then it's also a head of loss. So it is something that can be recovered, that the family that have to pick up this burden of deputyship, it can be dealt with by a professional, and the ongoing costs can be included within the claim. But just going back to the previous point, there is also a lot of work that needs to be carefully done and considered in terms of who is suitable, whether the person's trustworthy, whether or not the person is capable of acting as deputy. And sadly, we've seen cases, haven't we, Jade, where this hasn't been on early on, and it's led to problems with potential consideration of family members who are not suitable and not able to act. And where that's then led to problems, it's not only delayed the claim, but it can also potentially derail it. It can really cause significant problems in moving things forward. Now, the final point on this slide is just that the Section 19A of the Mental Capacity Act, the court asks a property affairs deputy to provide some form of security. Now, the security bond is in place to protect the funds of the individual, and the level of security is set by the court. And if we've got an ongoing litigation claim, in most cases, it will involve a requirement for the deputy to report back to the court upon settlement of the claim. And I think this is something that you've dealt with on a number of cases, haven't you, Jade, where we've had to put information together to submit to the court to show what the anticipated expenditure is, and then the court will usually review that at that stage. So it's just something to keep in mind, that the level of security, and again, those premiums will form part of the claim if that's appropriate. Okay, so the application process to appoint a deputy, and I think I will turn to Jade at this point, because this is something that Jade probably deals with more regularly than I do. And what we'll do is we'll just talk you through the process in terms of timeframes, the type of information that we need, if that's okay with you, Jade.
Yes, that's fine. So as part of the application, we need to draft a COP1 form, which will have the general information about who is proposed to be the deputy, details of P, such as their date of birth, their address, contact number, if that's appropriate. A COP1A also needs to be drafted, and that's more based around the financial information. So information such as, do they have a will? Do they have an LPA? Do they have a bank account? How much is in the bank account? Do they own property? So all the information to do with their finances. And then again, the COP3, which Thomas mentioned before, which is the capacity assessment. So we have had assessments come through before that haven't been on the COP3 form, which we can send to the court, but it's always better to send the COP3. I think you'll agree, Tom, to send it on a COP3 form.
Yes, that's correct, Jay. So what we've seen, and this is something we've seen recently as a slight development with the court as well, is that they have become more strict with that COP3 requirement. And in cases where we've tried to annex an assessment to a COP3 or provide it in a different format, they are being much stricter than they were previously about it being in that format. And there's also, I suppose, a point to make, there's a variety of professionals that can complete the COP3. And I think it's always a good idea to seek advice from the court protection solicitor that's drafting the application as to who might be most appropriate, whether that be one of the experts that's already involved in the claim, or whether it might actually be better to go to a social worker, to the GP. And I think the factors to consider in that are delay, costs, and trying to move the application forward swiftly. It's not a requirement that the court has to have the consultant neuropsychologist or consultant neuropsychiatrist involved in the claim completing the COP3, but it does need to be considered on a case-by-case basis. So who's the best skilled person, and then considering the issues around cost and delay. And then, so Jay, if you want to just sort of go on to then talk about the sort of time frame that we see with cases and the notice issue process, because I think that's really important for litigationists to understand sort of how long these cases tend to take to progress.
Yeah, so we found after we've made the application, we tend to have the application acknowledged fairly quickly, within 2 or 3 weeks. And then after that, we tend to see, well, a delay of about 6 months before we see an order, or maybe a request for further information. With COVID as well, there have been further delays. There's a notice period, and the application will then wait to receive judicial consideration. They'll be considered on the papers unless they're contentious, and yeah, we normally see that's around 6 months.
Yeah, and I say we 6 months is usually a good time frame to be communicating to the client and their family when we first meet them and explain the process, which is a very important part of making sure that the proposed deputy is suitable and that they're informed of what the process entails and what deputyship will entail once a deputy is appointed. I think we've got to expect that it's going to take longer than 6 months at the moment, especially for applications that have been caught up within that period. We've definitely seen delays. We have seen some positive things in terms of some of the applications being referred to more regional courts that were able to deal with them a little bit quicker. But the notice period is something that we've also had to think about carefully with COVID, because the protected party, whether that be a minor through an adult with parental responsibility, or the adult client themselves, needs to be notified in person. And we usually endorse that being done by the solicitor that's dealing with the court protection application. We've had to be flexible with some of the applications at the moment, where we've been asking care providers or relatives if they can assist with that notice due to the COVID restrictions and need to try and move the applications forward. The other thing is that it is possible in certain situations to make a further application within proceedings requesting the court expedite or fast track the application. Now, this is something that we see regularly, or we have requests to deal with regularly, and it's often because the claim started to move forward very quickly and there's interim funds available that can't be managed until there's a deputy in place. And whilst it is possible to make this type of application request that the court deal with it, there's no guarantees in terms of whether or not the court will consider it suitable for fast tracking, and it really is something that should be used as a last resort. It shouldn't be used as a means to try and undo poor planning from the past. Of course, there'll always be situations where a claim will start to move on quicker than anyone anticipated, and we've tried to use we have successfully used this to speed up the appointment of a deputy. But it really is a last resort, and there's no guarantees with these applications, because it depends what else the court's got in front of it, and it depends on the evidence that we submit. And I know that Jade's dealt with some of these fast track applications, and so what were your thoughts on this, Jade, and what would your advice be around the sort of information that we need and the type of results that we've seen from these applications?
Well, as you say, you need to have a really good reason as to why you want it expediting. So, for example, in a case that we've dealt with, it was all to do with an interim payment had been received, but they were unable to spend the interim payment on care or equipment. They needed a deputy to consider, whether the equipment or whether the care could be paid for out of the interim. So in that case, it was drafting the COP9 form and just outlining the reasons of why we felt that it needed to be expedited. It did come through quite quickly. It was only a matter of weeks, which was a very quick one.
This is a useful tool that we can use in cases where there's been an unexpected interim and things have moved forward quicker than anticipated. But I really think it's something that should not be relied on there, because as I say, in that case, it was a fantastic result. It was dealt with in weeks. We had the deputy application. We were able to implement the care and support that the client needed. But in many other cases, we still have to think about the court protection in terms of months, not weeks. And really, the other thing is with this, if we're firing cop nines in left, right, and centre saying that every case is urgent, effectively no case is urgent from the court protection's perspective, because if they receive too many of these applications, then the ones that really are important will get lost. So that's a useful tool that can be used, but say I would guard against it and I wouldn't rely on it. Okay, well, moving on to the next issue. So the general ruling in cases concerning protected parties' property and financial affairs is that the costs are paid by the protected party, which is why when we look at the issues around deputyship and professional fees for a professional deputy, that these costs are met by P and can form part of the claim. There's strict rules in terms of the cost being assessed. There's also rules for fixed fees that don't require assessment, but I think the majority of cases that we deal with involving litigation awards, because of the complexity, because of the level of involvement of the deputy, they tend to fall aside from the fixed fee rules and more into the costs that require assessment by the SCCO. In terms of the conduct of parties in litigation, if there's contentious issues, if we've got a case that involves safeguarding around someone that wants to be involved in the person's affairs that we don't think is appropriate, if we are making applications that have not been properly thought through and contested, the court can depart from the general rules. So there's no guarantee, and it's something to be, I think, increasingly cautious about just making applications around finances that have not been carefully thought through, because there is that risk in terms of costs, which is appropriate there to protect the protected party and ensure that we're not just making applications that are not appropriate. Where there's cases that revolve statement on future deputy costs, that's something that we're able to assist with. I think some of the key things to think about, and I know that there's a series of webinars that we're also looking at the welfare issues around the court protection, is how those welfare issues can implement and have an impact on the role of the deputy and the costs of the professional deputy. And I think those are really important things that need to be included as part of the projected ongoing costs of deputyship. Another area that we see in some of the statements that we review and advise on is that actually I think contingency costs for these ongoing deputyships are really underestimated in a lot of cases. Whilst it might be possible, and it's actually a requirement of the OPG that we have to forecast and estimate annual costs for deputyship, these cases can be very unpredictable. We have to react to what's going on the ground. If we've got clients with brain injuries in particular, then there can be a lot that's happening, and it's very dependent on what's around them. So I think the contingency is a very significant element that's sometimes overlooked, as another issue that's important is testamentary capacity and ensuring that things like the statutory will are included in those costs, and again have been carefully considered throughout the claim from an early stage. And just going back to the point about capacity being time and issue specific, I think it's important to think about capacity at the outset, but also think about it when a claim's ongoing, whether that be that there's been a determination that the person lacks capacity, or in a case of an adult or perhaps a minor where there's potential for progress, whether it's been determined that we're not able to comment on capacity at this point, but we might be able to at another point in the claim. So just because there's been a determination either way at a point in a claim, keep that under review. And that's an issue that a court protection solicitor can really assist and advise on, that they should be able to give you information about when's appropriate to consider it and who might be the most appropriate professionals to consider it. Okay, so just looking at some of the points in respect of deputyship prior to settlement of a litigation claim, that the deputy needs to be very involved as an integral part of the multidisciplinary team that are working with the client and working with the litigation solicitor to keep them updated, keep them informed on what's happening, working together as a team really to ensure that the funds are managed in the best interests of the protected party and in accordance with the interests of the claim. I've seen cases where actually if it's not done appropriately, a deputy doesn't know what's happening in the claim, is not responding to it, or if a deputy is going off on a frolic of their own and doing things that might even be in the best interest of the protected party, but don't tally up with the purpose of the claim and the aims of what interim payments have been provided for, then it can cause significant problems with the litigation claim. The client and the family and their members need to be consulted and central to all of the decision-making process. Including identifying the suitable deputy. I mean, it's very important that the relationship works well. We don't want to see a breakdown relationship of that of that relationship during the litigation claim. It's possible it could happen for a number of reasons, and it should be something that's forecast within the future deputy costs. But if it happens during the litigation claim post-settlement, or prior settlement, sorry, then it can really cause problems in terms of the management at the interim and ensuring that the claim progresses smoothly. So this is why it's so important that everyone's consulted and everyone's very much involved in this process. One of the things that we're often asked to do is produce income and expenditure records. If these can be done in a way that assists the litigation solicitor, then that's very important. We would always consult the litigation solicitor, wouldn't we, Jade? And I think this is something, again, that you've worked on and perhaps dealt with it in different formats.
Yeah.
And so it's always important that that's done appropriately and done in a way that assists the litigation solicitor and helps the claim move forward quickly. Similar to this, the deputy needs to be involved in retaining and filing receipts and other key documents. And this is, again, something that Jade works with very, very closely and ensures that it's very organised and in ways that can be passed litigation solicitors onto counsel. And just finally, a point that sometimes gets overlooked, I think, in litigation claims, that the deputy is also there still to safeguard the finances, which might sound obvious because that is a key integral part of the deputy. And I think that what I mean by this is that in other cases where we're appointed by local authorities or cases where there's been issues with the OPG, sometimes safeguarding can be at the forefront of the deputy's mind, whereas I think sometimes where there's an ongoing litigation claim, it's important not to overlook the issues of safeguarding. If there's still individuals involved around the person in that capacity that could have a detrimental impact on them and their welfare and the management of their finances, then that, if it's not carefully monitored and dealt with quickly, can eventually feed into the litigation claim and causing problems with the progression. And that is something that we have seen in another case where the issues were not very well managed in terms of ensuring that the appropriate people on the ground were in place and were being carefully monitored and scrutinised. So that remains an important part of the deputy's role, even prior to settlement of the claim. Okay, so just moving towards the end of this session now, we're just looking at some of the tips that hopefully we've mentioned as we've gone through this presentation. The first one is to consider mental capacity when instructed and an ongoing basis. As I've just mentioned, it's time and issue specific. So there could be various elements to the issues around capacity. It could be capacity around where the person lives, the care and support they receive, the management of their finances, testamentary arrangements, one-off decisions around a property purchase. These all need to be kept under review. And if we're thinking about the appointment of a deputy, a number of these other decisions have significance to the deputyship, but also the litigation claim. It's important that it's thought about as early on as possible, the timeframes and delays that we've mentioned, the court protection, but then also on an ongoing basis. And to assist with that, I would suggest consulting the court protection solicitor or the proposed deputy at an early stage possible. As we've mentioned, don't underestimate the timeframes involved with appointing a suitable deputy, or if it requires a one-off application, as mentioned with the next point, try and tally that in with the deputy application. You don't want to go through the process of an 8-month application to appoint a deputy, and then because there's not been joined up thinking for the deputy or the litigation solicitor to realise that the deputy orders don't have the relevant authorities to deal with issues that are relevant from the perspective of the claim and the interim payments, such as purchasing a property. Additional authority might be required if the deputy is going to go off and appeal in the HCP on behalf of a client. That I know can have a significant impact. The arrangements around school provision can have a knock-on impact on what's intended with therapy, support, all aspects of the claim which are very important during the use of the interim payment. So try and ensure this joined up thinking is in place from the very outset, and it's early on, and it's been regularly considered and reviewed on an ongoing basis. Obtain robust evidence on future deputy costs and consider the client's individual circumstances. As we just mentioned on a couple of slides ago, the evidence around future deputy costs, it needs to be very clear, and it needs to be thinking about some of the wider issues, not just the management of the finances. What's going to happen as this person's life develops? What welfare issues might be relevant to the deputyship costs? Is the contingency sufficient? Will we need to make further applications to the court protection? This is something that we can assist with, and we think this is a very significant part of the claim. From the schedules of loss I look at, the ongoing deputyship costs is usually one of the most significant costs in the client's lifetime. So make sure that that's something that's being thought at again from an early stage as possible, and that there's appropriate people involved to assist with this. And again, just going back to this point that I've made about safeguarding concerns, and this isn't just the role of the deputy, this is the whole team involved. Be alert to this and don't be afraid to take action at an early stage. I think that the issue of safeguarding is, and I do separate training sessions on safeguarding, particularly for local authorities, that safeguarding can be very difficult to identify, but it can also be very difficult to resolve if it's gone on for a long period of time. Whilst it might be possible to step in and prevent ongoing safeguarding, trying to unravel and undo the damage that might have been caused can be very, very difficult and often impossible in certain cases. And if there's an ongoing litigation claim, the last thing you want to jeopardise it is something around safeguarding that could have been identified, picked up with and dealt with at a much earlier stage. So those are the tips. Have you got anything that you would like to add with that, Jade? Anything around the COP9 applications and the information that we report back to on litigation solicitors?
The only thing that I would add is just about fee remissions. So there's a fee remission form. It's very similar to the one that you use in the ClinNeg and PI cases. And again, that can be used so that the application fee isn't paid in circumstances where somebody is eligible. So that's just something to bear in mind as well.
That is a very important point. And I think we'd consider that as part of the information gathering stage, wouldn't we, Jade, where we're looking at the information we need to consider an application, the capacity evidence, all of that at that point in time, because I know that it's important to get all the information in the application, because we don't want additional delay with the court coming back and saying you haven't included this. And if we can get a fee remission, then that's a saving of £365 for the client, although it might subsequently become payable, which again is important to consider as part of the claim if that's going to be included. Okay, so just finally, the final slide is just a summary of the work that we can assist with price-related Gordon solicitors. I hope that you find this webinar today helpful. So we'll try and deal with the questions as we've gone along if any come through. Otherwise, we're quite happy to take telephone calls, receive emails, or set up a Zoom webinar or something separate with individuals who want to discuss a particular case. We're always happy to try and assist where possible, and we hope you found it useful. So thank you very much.
Right, thank you very much, Tom and Jade. That was really a tour de force, wasn't it, of the application process, and the tips I particularly thought were really, really useful. So we've been fielding some questions, or trying to gather some of the more important questions that have come across and see if there's any common themes. Ariana, you've picked up on one or two questions that people want to ask Tom?
I have, and Tom's been good enough to answer these in writing, but they're given that they're really interesting questions, we thought it might be good to discuss them. So Tom, you had a question from anonymous attendee. Feel free to be anonymous or join in with a name. Following the case of ACC, how is best to deal with the three quotes aspect when the COP is passing a potential PI ClinNeg claim within the firm? If three firms are approached, each firm is likely to say they would deal with the claim on a no-win, no-fee basis. So how can it be shown that acting in-house is in P's best interest?
Well, I think it always needs to be considered on a case-by-case basis, and there's evident importance with the obtaining of the three quotes, but I don't think that's the only factor that the court will consider when an application is submitted. And it's important that the application is drafted in a way that it highlights and brings to the court's attention the other issues that are relevant to considering that type of application. So we've seen with cases where quotes might be very similar, and we've still submitted a statement in support of using a particular firm, whether that be in-house or an external firm. And there's obviously, whenever a case is dealt with in-house, there are other factors that are relevant to potential client benefits and demonstrating to the court why that's in the client's best interest. So I can appreciate that sometimes there might be not a great deal of difference between the quotes alone, but that's not the only factor that we see the court considering, provided the application is drafted with all the supporting information that's required to explain why the preferred option has been put forwards.
Great. Super, thank you, Tom and Ariana. One question that came across, and perhaps I'll put this to Francesca and Ariana, both of you, is that have you come across any cases where Section 58(5)(b) of the Mental Capacity Act has been instigated? And to assist, and I have to put up my hands and say I wasn't aware of this particular paragraph. To assist, it says 58(5)(b) that for the purposes of enabling him to carry out his functions, the public guardian may, at all reasonable times, examine and take copies of any record or held by a local authority and compiled in connection with social services function.
Sure, and just to kick off on that, to say for anyone who may not be familiar, the Office of the Public Guardian would hold a general responsibility for overseeing the work of holders of lasting powers of attorney or deputyships. Within that function, obviously, as Tom emphasized in his talk, safeguarding is an extremely important function because you are talking about a population of very vulnerable people. So it's not uncommon for the Office of the Public Guardian, when a concern has been raised about how an attorneyship or deputyship is being used, to make inquiries of the local authority, which may have safeguarding responsibilities for the person, to try to find out what's going on, because people on the ground working with the person may often have a much better idea of what's going on and the nature of the concerns that are being raised. I also have to admit, I had to look up the specific paragraph of the Mental Capacity Act Code of Practice on this question, but what that referred to was talking about an attorney or a deputy, when there is potentially a safeguarding issue around a person, may have a need to raise a question with the Office of the Public Guardian as to how function should be carried out, or just to raise that as a general concern. So it may be that you have a deputy or attorney who's seeing a problem which is going on, raises that concern with the OPG, and the OPG comes back to the local level with the local authority to make that inquiry as to what social services is seeing. Now, one thing I would also say is that if there is a deputy or attorney who is seeing a problem on a safeguarding basis, it would always be appropriate to approach the local authority safeguarding with safeguarding responsibility for the person directly and do that, rather than going through the OPG, or to approach both of them simultaneously. But certainly, I know in all of our practices in the Court of Protection, you do sometimes see very urgent issues arising where the person seems to be at significant risk on a very short-term basis. They seem to be at risk of losing large sums of money. They seem to be at risk of physical harm. And I think in those bases, it's important to make sure that you're getting to the person who's going to be able to take action as quickly as possible. This is going to be an issue that we'll be developing further, and I know Francesca will be talking about where the limits of deputy authority lie. So maybe I'll hand over to her on that point.
Thanks.
Yeah, I mean, I think I can cover that when we get to my section in the seminar. Just to say that my experience is the same as Ariana's, and I also haven't heard of this issue coming up in a PI or Clin Neg context. So I'd be really interested to hear about any scenario where that's come up. And I know there's a panel discussion at the end. So if whoever it is that put that question, if you could let us know how that's come up and the context, that'd be really interesting.
So there's an invitation, Mr. or Mrs. or Ms. Anonymous. Okay, well, I think that's where we'll leave it for the questions for the time being. Obviously, we're open to questions and answers at the panel discussion and thereafter. But let's move on to the second part of the seminar, where Ariana is going to discuss with us how to obtain evidence about someone's capacity. Ariana.
Thanks very much. Making sure I'm able to share my screen successfully there. So what I'll be talking to you about today is capacity, what capacity evidence is, what mental capacity is, and getting capacity assessments as evidence. One of the reasons I really highlight this and go into it in so much detail in this talk is because capacity is always the gateway to the court of protection. It is the foundational question on which any court of protection orders can be made, but it can be a really tricky concept because there are a lot of moving parts to capacity. And I think it's important to understand the nature of it in order to understand what the court of protection will actually be looking for when it's considering capacity evidence. So in the Mental Capacity Act 2005, the question around capacity is about making decisions. Is a person unable to make a decision due to an impairment or illness of the mind or brain? As a matter of law, capacity is always presumed until that presumption is displaced. But if the issue arises, it should be investigated rather than relying on the presumption. I often liken this to a shield rather than a sword in terms of incapacity, because sometimes you do get scenarios in which a person may lack capacity, may be unable to understand what's going on in terms of the decisions which are being made, but it's not necessarily recognized. I've seen a couple of cases, including cases where people stood to lose out on major sums of money in litigation, where the question simply hadn't been considered. People had simply relied on the presumption of capacity in that case and said because there wasn't evidence that the matter was closed at that stage. What I would really emphasize, and case law over time has come back to this point again and again, is that this is about not making any unjustified assumptions about what decisions people are or aren't allowed to make. It's not about presuming that people who are obviously having difficulty shouldn't even have their capacity considered. And it's always a really important question to look at. The Methyl Capacity Act 2005 poses capacity as a two-part test. The first part is the diagnostic test. This is the nature of the person's condition or mental state. The second part is referred to as the functional test. This is about how the person's condition affects his or her ability to make decisions. As Tom noted, capacity is always time and decision specific. It's about the decision that needs to be made at the moment that the person needs to make it. This can come up in several different ways, and it is really important to keep capacity under review rather than presuming it as a static function. And this can certainly go both ways. Something that we see very often in the Court of Protection for people who are going through forms of rehabilitation, very often brain injury rehabilitation, their abilities can improve over time. They can become more able to make decisions than they once were. Something else that you often see, both in the brain injury context and often in a learning disability context, is that people's lived experiences can also change their ability to make decisions. For some people, abstract concepts can be really challenging, but once they've actually been to a place, learned more about it, met the relevant people, they're much better able to use and weigh information about the decision which needs to be made. So their capacity really can improve by that experience. On the other hand, you also get people who have fluctuating capacity, or people who may lose capacity in times of extreme stress or anxiety. And as the circumstances change around them, perhaps a relapse into drug or alcohol use, or just general high levels of stress or anxiety in their life, their capacity may really suffer in those cases, and they may be unable to make the decisions which are once able to be made. So this is why it's always really important to think about capacity at the moment that the decision needs to be taken. It can't be seen as a steady state in a person's life. So looking at the two parts of the test, the diagnostic test under Section 2 Mental Capacity Act is really important because the Mental Capacity Act is only about people who are unable to make decisions due to an impairment or illness of the mind or brain. The Act does not prescribe a set list of diagnoses. It doesn't matter whether the person's mental impairments or illness is in the DSM, and you do sometimes get cases in the Court of Protection where it's difficult to come with a specific diagnosis for the person, but there may yet still be a finding of a cognitive impairment, even though it's not possible to dig down further into it. This could be a brain injury, it could be an organic impairment or a mental illness, many cases of dementia, the whole gamut of any sort of mental impairment or illness, or any impairment or illness of the brain could potentially fulfill the diagnostic criteria of the Mental Capacity Act. What's important about this as well is that whatever the nature of the impairment or illness, it must be the cause of the person's inability to make a decision. It's not sufficient that you have someone who simply has some impairment or illness in the mind or brain and isn't able to make a decision. There has to be that causal link between the two in order for the Mental Capacity Act to find that the person lacks capacity in that relevant area. If anyone is counting how many times I've said capacity, I'm going to guess it's at least 25. I'll see if I can hit a good century by the time I'm done with this talk. Evidence of mental impairment or illness will almost always require some form of medical evidence to confirm a person's diagnosis. The key issue being whether an impairment or illness of the mind or brain exists. In the PI context, this is likely going to exist because you will be looking carefully at the nature of the difficulties that the person has and what injury the person might have suffered. However, there are some cases within the Court of Protection where a person simply refuses to allow assessment to happen. This can often come up where a person disagrees that they have any sort of difficulty or really rejects the whole concept of it, or people who are very skeptical of medical treatment. Usually, it's not going to be proportionate to use any sort of force to insist on imaging, particularly where you're looking at longer term scans or interventions which may require a long period of time for the person to sit still to confirm diagnosis. But what's important to look at, and I'll be talking about this more, is that these sorts of difficulties are not necessarily prohibitive, and you have to look at all of the evidence in some of those cases where challenges can arise. The functional capacity test looks at 4 questions. The first question is whether the person is able to understand information relevant to making a decision. And in the context of the Methyl Capacity Act, that means the reasonably foreseeable consequences of making one decision or another, or in not making a decision at all. The next question is whether the person is able to retain that information long enough to make a decision, whether they're able to use and weigh up that information in the decision-making process, and whether they're able to communicate a decision. I would say the 4th prong of the test comes up very, very rarely in the court of protection. There is a very strong emphasis in looking at capacity to making sure that the person has had all practical assistance to be supported to make a decision on their own. And around communication, that's often one of the areas where the court is probably going to be least likely to accept that if there is reason to believe if the person is able to understand, retain, and use and weigh, they wouldn't want to be cut off the pass by an inability to communicate a decision. I will say one of the most staggering capacity assessments I've ever seen was a case where the person was deaf, and the hospital in that case said that they were unable to find a BSL interpreter on that day, so they presumed the person not to have a capacity. I can only begin to describe what an utter failure of upholding the principles of the Methyl Capacity Act that is. It's always absolutely incumbent to try to make sure that those sorts of difficulties can be overcome. And I've seen a variety of techniques used to make sure that communication can happen, even down to a person being able to squeeze another person's hand in order to communicate what it is that they want. Now, going to this question is, what if you have a concern about the person's capacity, but the person doesn't want to be assessed, either for the purposes of diagnosis or something we see not infrequently in the court of protection, a person simply refuses to engage with a functional capacity assessor, because that obviously does involve a degree of willingness on the person's part to answer questions which are being put to them about whatever the relevant decision to be made is. There was a really important case in Zed and County Council, which looked at how the presumption of capacity could be treated. In that case, it was a question of litigation capacity, and the litigant in the case was displaying behaviors that were odd, to say the least, and there really ought to have been concerns as to whether or not this person was making capacitous decisions. What the court said is that one significant intention of the presumption of capacity is to prevent inaccurately assuming lack of capacity in apparently vulnerable individuals without it being properly established on evidence. It is emphatically not there to obviate an examination of the issue, nor can it have been Parliament's intention to place a vulnerable person in danger of their lack of capacity being overlooked at the expense of their rights by a slack reliance on this presumption. This, I think, is hugely important, and I think this is something that comes up certainly in the litigation context, but also in the broader care planning context as you are looking forward to the next steps after a person has received an interim payment or a longer-term award. There has to be an active consideration as to a person's capacity if these issues have arisen. And again, this is not to say that the presumption is minimized in any way. The presumption is extremely important, and all people start with the presumption of capacity. But it does mean that the people who are working with the person have to be alive to these issues. They do have to consider this. They do have to look at whether or not this person may not be making capacitous decision, and they do need to explore that if the issue has arisen. Now, to my view, what I would say is that where all reasonable efforts have failed to get the person to engage in either diagnostic or functional assessment, the court may consider this question on the balance of probabilities, and it's not impossible to make an application to the Court of Protection without it. There have been a number of reported cases where the person simply refused to engage in any way with the assessment process, and the court was left with no other choice but to make a decision on the basis of a balance of probabilities of the evidence out there. This is obviously not the preferable way of doing it. Formal evidence is always very, very strongly preferred, particularly if the court has to make a determination of diagnosis. And I would say if you ever do find yourself in a position of having to try to proceed forward without the person having engaged in a capacity assessment or without the person having had a firm diagnosis, you would almost certainly need a hearing. The person would certainly need to be represented. This would obviously greatly increase expense and litigation risk. This is not in any way to encourage anyone to proceed forward without that sort of evidence. But it is to say that if this is what the person needs, and there is reason to believe on the balance of probabilities that the person doesn't have capacity, that issue does need to be flagged up. it does need to be addressed, because to do otherwise potentially leaves you in the situation where the person may be making decisions that aren't actually based on the relevant information and aren't actually based on a real using and weighing of that information. There are a couple of other principles under Section 1 of the Mental Capacity Act which are relevant to assessing capacity. The person is not to be treated as being unable to make a decision unless all practical steps to help him to do so have been taken without success, and a person is not to be treated as unable to make a decision merely because he makes an unwise decision. All practical steps to assist the person in making his or her own decision include ensuring that the person is provided with the information about the choice made. It's incredible how many capacity assessments you read which start with a question of, tell me what your needs are, or ask the person questions of, tell me how you got here, and are really relying on the person to be able to provide the assessor with all of the relevant information. Case law is really clear on this. It's up to the assessor to put to the person what their needs may be, what their finances are like, what the actual available options are in the decision which needs to be made, and what are the risks and benefits of deciding one way or another or not at all. Retention of information is also only necessary for the period of time that it's required to use and weigh the information to make a decision. This is again really important, and this is set out in the Methyl Capacity Act Code of Practice. The person doesn't necessarily need to have a particularly long-term memory. They need to be able to hold the information in their mind for long enough to make the relevant decision. And if they're able to do that, they may well have capacity. But capacity assessments are not memory tests, and it's not necessarily incumbent on the person to be able to remember things that have been put to them in the past if it's not necessary. The case of CC and KK is always a leading authority on issues of capacity, and it does raise this really important point that it's inappropriate to start with a blank canvas. You have to give the person full details on the available options either way. And in a case where you may have two options, or you're talking to a person about how their care needs might be met in the future, you have to be able to outline to the person what those choices would be. In questions about managing their affairs, you have to be able to set out to the person what the risks and benefits are of making a decision one way or another, or of managing their finances one way or the other. In litigation, you have to be able to set out what the risks and benefits would be of making a decision on either side. This again really gets back to the specificity of capacity, and this is something courts have come back to, and increasingly in recent years, and this is a case that Sam and Francesca were both involved in. Courts have really specified it's not about general capacity in a broader sense. It's about capacity to make the decision which is actually at hand. And in getting evidence on capacity for court of protection proceedings or even litigation capacity, this is really important in the letter of instruction, that you look carefully at what the decision that actually needs to be made is. There has to be clear and specific thought given in the letter of instruction to the assessor to what the consequences are one way or another. This involves a lot of background in terms of understanding what the person's circumstances are and careful preparation so that the assessor, when they're in that assessment, is able to put that relevant information to the person. There's quite a lot of thought that's needed in that in terms of actually outlining that information rather than just relying on a precedent list. It's really about this person's situation and what's relevant to his or her decision rather than what might be relevant in other cases. Just briefly touching on litigation capacity or capacity to conduct proceedings, the courts have again come back to the point of specificity over generality. The question is capacity to conduct the proceedings at hand and not more generally. And a person may have capacity to conduct proceedings, but may lack the capacity to administer a large award. And it is always important to try to think about those decisions. And again, trying to respect the fact that when a person is found to lack capacity, this takes away their autonomy to make decisions which can be extremely important about their own life. And there should always be a view to thinking about what the person may be able to do for him or herself. Something that you do see commonly in deputyship situations is that even if a person is unable to manage a large award, consideration needs to be given to allowing them to have discretion over their day-to-day spending or other sorts of decisions which they may have capacity to make. And assessments always need to be alive to that as to how far the person's capacity may go and where it may stop if there is a view that they don't have overall capacity. I would note that for the purposes of assessment, some decisions are commonly bundled together for the purposes of court applications. Certainly, and this is something addressed in Dunhill and Bergen, the question of litigation capacity is itself a series of micro decisions the person has to be made. but practically they do have to be bundled together for that purpose. Property and affairs is generally seen in much the same way. It's generally seen as lacking capacity to conduct one's property and affairs and to administer one's property affairs. But really, when you think about it, there are so many smaller decisions within that. It's not one decision, it's managing one's property and affairs. It's a series of micro decisions. There's a bundle of sticks approach as to what decisions a person can make for themselves. In the same way, it's very common to see declarations that a person lacks capacity to make decisions as to their care. But again, care is a series of acts. It's a series of steps which are taken for the person. It is a useful shorthand and something courts have come back to, and particularly in context of fluctuating capacity, is the issue that there has to be some aspect of administration of how decisions are going to be made. And it's not necessarily practical to stop at every moment of a person who may be lacking capacity and to determine what they are and aren't able to do. But what I would say is, in terms of these macro decisions, it is important to think about how much the person can do and actually to try to apply that as practically as possible, particularly in property and affairs, looking at making sure that the person is able to retain whatever autonomy they're able to have, such as managing their weekly shopping, managing a smaller budget of discretionary funding for themselves, and being able to retain some of that power for themselves. In terms of the evidence that you may need to seek for court of protection proceedings, and I apologize if I don't have a clock in front of me, so I hope I'm not running too late, and I hope Sam will intervene if I am. The evidence question is the key question within it is whether the impairment or illness of the mind or brain causes the functional lack of capacity. Usually you're going to be going to a doctor or a psychiatrist who can comment on the impairment or illness and how that affected the person's ability to understand, retain, and use in way. Because it is that link, and you need someone who does understand the diagnosis well in order to say how that would affect the person, how it does affect the person in this particular case, and to link the two of them together. What I would say as a person who reads an ungodly number of capacity assessments every year, having an experienced capacity assessor who really understands the process and principles is extremely key. This may or may not be the experts who worked in the PI proceedings, and really depends on context. What I would say is there are an enormous number of people who assess capacity without really engaging in the Methyl Capacity Act principles. It is depressingly common how often you see capacity assessments which are a few lines long, simply saying P lacks capacity, P lacks insight, without really engaging in these questions and showing why that is. The Court of Protection is becoming an increasingly sophisticated jurisdiction over the years, and it is needed, assessments are needed which do engage with the principles that actually show this, because of the gravity of taking away people's choices for themselves. What I would say is that in practice, while you do most often look to doctors or psychiatrists to do that, there are many other professionals who assess capacities, many psychologists, many social workers, and quality doesn't necessarily follow professional designations, and not all doctors who regularly assess capacity do it well. A person who's acted as an expert witness in the Court of Protection or as an Office of the Public Guardian visitor would generally be a good indication of a person with a good track record. But obviously, I'm sure Tom and I'm sure any of us would be happy to discuss with people any recommendations we have of quality capacity assessors who may be able to assist in this context. Also, as a note, it's really key to provide that clear letter of instruction so that the assessor does understand the person's circumstances, background, and particularly that relevant information regarding the decision at hand with detailed information. I would note, interestingly, on property and affairs, there are some cases where the court has approved withholding information about the size of a person's award due to the effect that it would have on the person to know that information, specifically that it would have a very detrimental effect. But in general, absent an application to the Court of Protection to withhold information about the size of the award, this typically would constitute relevant information about whether or not the person is able to manage their property and affairs. So this is another aspect of the interplay in terms of thinking about whether the person is able to manage that award and is able to manage their property and affairs. There does need to be some sense of the scope of it and what would actually be involved in the management of that award. So that's my whistle-stop tour of capacity, but obviously this is what we do, and we're always happy to take any questions or discuss any issues around capacity or getting evidence around it for the purposes of making applications for, to the Court of Protection in either the property and affairs or health and welfare jurisdiction.
Great. Thank you, Ariana. Just super. And I'll just put everyone back on share gallery. Super. One of the things that I just wanted to touch base on is fluctuating capacity, and Ariana, you just touched on it in your talk there. I'm aware of kind of conflicting authorities on fluctuating capacity, because there's that great Greenwich case where Mr. Justice Cohen made a declaration that someone lacked capacity and made a declaration essentially of fluctuating capacity. How does that work with respect to, say, individuals who have acquired brain injuries, for instance? I mean, when their capacity goes in and out, because I'm acutely aware of what the code of practice says, which is that, and you touched on this earlier, that capacity has to be time specific. So how can the court, I suppose, make a declaration that someone has fluctuating capacity when the code of practice says it has to be time specific? I mean, how does that work? Do any of you have experiences as to practically how that works on the ground?
I don't know. Do you want to go? I was just going to say that in relation to that, I've had a few cases where there is clearly that the individual has fluctuating capacity, and as you say, the difficulty then is how do you square that with the way that the statute's drafted and the code of practice? And I think the recent decision from Mr. Justice Cobb is the Wakefield case. I think he identified a really quite clever way of doing it. As I understand it, in that case, the protected party was said to have fluctuating capacity at times of, and this is the judge's words, having a meltdown. Yeah. And the difficulty was then, at those times, he was unable to consent to his care arrangements and they then needed to be authorised by the court. But it wasn't a continuing problem. So the way the court approached that was to say that there would be an order authorising any person to deprive P of his liberty and to impose the care arrangements on him at times that he had a meltdown. And for that order to be enforceable and applicable, steps would have to be taken at that time to assess his capacity. Not an in-depth capacity assessment in the way that Ariana's taken us through, but steps to be taken to identify that that person was in a particular phase of meltdown. So I think it's really case specific, and it's such a tricky issue that comes up all the time as well in medical treatment cases. But there are ways around it, I think, by care planning properly and ensuring that those on the ground tasked with caring for the individual or taking the decision in hand, the relevant decision, know the steps they need to take to identify whether in that moment that person does lack capacity, and then whether or not any order that might be made bites. So that's sort of a real summary view of what's quite a complex area, but there are I think 2 or 3 judgments now, if you include the recent decision from the Vice President, that conflict in terms of what the court can do where a person has fluctuating capacity.
Yeah, I mean, that decision from Mr. Justice Cobb is useful, isn't it? Because it almost sets out a saying where support workers and carers identify when that person has a breakdown, for instance, and then they utilize the declaration that they lack capacity to make decisions on their behalf. But do you think, and I don't know if everybody else thinks about this, but do you think at that particular time the carers and support workers should be doing a further assessment of capacity, or they're just relying on the court's decision that there's fluctuating capacity and they're just identifying factors which will guide them and authorized by the court, I suppose, in deciding whether someone at that point lacks capacity?
Yeah, I think that's where it becomes really tricky and becomes really case specific, because in that case, as I read it, the judge was satisfied that as long as the care professionals that know him well were satisfied it was a meltdown, as described by the experts in the case, then that was sufficient. There must be cases, though, where it would be necessary to complete a fresh capacity assessment, and I've certainly had those cases. So it must be fact specific, I think. Yeah,
super. Anybody else want to come in on that? Okay. All right. Okay. Well, I'll stop the questions there, because we'll just swiftly move on to, Francesca, your part of the discussion today, where you're talking about the authority of property and affairs deputies and applications. Francesca.
I'll just try and share my screen. I hope that's worked all right for you all. I'm going to discuss this afternoon the authority of a property and affairs deputy, the general authority of deputies. I hope we can set out some of the limits, some of the discussion points that are certainly going on amongst practitioners at the moment, and some of the areas that anybody involved in a PI or ClinNeg claim will need to know about in terms of the sorts of applications that might be required in the Court of Protection and the extent to which they need to be factored in to any claim, but also the extent to which applications may need to be made by a deputy. So for those of you still with us and still engaged, well done. This is the last slog, so bear with me. As I say, I'm going to try and talk about the general authority, authorisation of care arrangements, and all of that comes under the umbrella of ACC, which was a really significant decision handed down by Senior Judge Hilda earlier this year, which provides clarity and guidance on what falls within the general scope of a deputy, what doesn't, but what sort of things a deputy will need to be aware of and potentially take steps in relation to. And one of the key issues that I hope to touch on in the time that I've got is the extent to which a property and affairs deputy can become involved in issues relating to health and welfare, and the extent to which they actually have a duty to do so and a duty to take action, even though there may only be an order appointing them with general authority to make decisions about health and welfare. So the decision in ACC, for those of you that haven't read it, and if your practice area just simply hasn't touched on it, I would recommend reading the judgment in full. I think it's really well crafted, it's set out really clearly. And I say the caveat with this talk is that I haven't gone through the detailed provisions of it. It wouldn't be possible to do so in 20 minutes, but I've highlighted the key points, and then hopefully we can focus in on the discussion points in terms of the crossover between health and welfare and property and affairs. The case involved 3 individual cases that Senior Judge Hilda joined because of the similar issues. All of the protected parties already had a deputy appointed for their property and affairs, and none of those appointments and orders contained any express provision either granting or excluding authority for the deputy to instruct solicitors or to conduct any kind of proceedings. So the key issue really before Senior Judge Hilda was whether or not, under the general scope of a deputyship order, a deputy can take steps to instigate litigation, take litigation on P's behalf, and instruct solicitors. And the key issues, having heard from all parties, the agreed list of issues for the court, I've set them out there. So what authorisation is required to conduct litigation on behalf of P? What about further proceedings in the Court of Protection, which we're going to come on to? What does general authority actually include? Where's the line drawn between seeking advice and conducting litigation? Urgent matters, conflicts of interest, which I'm not going to cover. We've already talked about that and about the importance of ensuring that you have those 3 separate quotes before instructing solicitors, and certainly instructing solicitors within your own firm. What about cases where the deputy is not an instructing party, the deputy acting as litigation friend, and what if P has capacity to give instructions for the work in question? So there was a lot for the court to consider. The conclusions, which I hope to just go through relatively quickly, were that firstly, the general authority to manage P&A, which is granted by the standard terms of a deputyship order, encompasses those common ordinary tasks which are required to administer P's estate efficiently. An authority to make a decision to do an act in respect of P's property and affairs encompasses such ordinary non-contentious legal tasks, such as obtaining legal advice, as are ancillary to giving effect to that authority. And I've just listed there some of the steps and actions that the court clarified fall within the general authority of a deputy. And they went to practitioners that are practicing in this area routinely. They weren't a surprise. It was the areas that the court said don't fall within the general authority that were perhaps a little bit of a surprise, and provided clarity as to what can and can't be done. And it has changed practice quite significantly, in my view. The first is that specific authority is required to conduct litigation on behalf of P, except where that litigation or contemplated litigation is in the Court of Protection and is in respect of property and affairs issues, or to seek a direction in respect of a welfare issue. And that in particular has caused quite a lot of debate and discussion about, well, what does it actually entail and what does it mean to seek a direction on a welfare issue? Teenager Childer went on to say that where a deputy has authority to make a decision or do an act in respect of the property and affairs of P, such authority encompasses steps in contemplation of contentious litigation in the realm of that authority up to receiving the letter of response, but no further. And again, that's quite a significant development and confirmation from the court, because I'm sure Ariana and Sam will have the same experience, but prior to this decision, I was routinely advising professional deputies about whether or not recovery action should be taken on behalf of P, particularly in cases where there'd been financial abuse. And the question was whether or not civil proceedings should be instigated to seek to recover those funds that were obtained sometimes by undue influence or financial abuse. And then that steps could be taken by the deputy to do that. And what ACC has clarified is that doesn't fall within the scope of a general authority order granted to a deputy. And in fact, you would need the Court of Protection to give you permission to do that. So that's quite a significant change in practice. The court went on to say that general authority of a deputy does not encompass seeking advice or other preliminary steps to litigation in respect of welfare issues. It does encompass making an application to the COP for further directions or specific authority in respect of welfare issues. And I'll come on to a concrete example in relation to this. But all of us, I think, certainly on this session, have experience prior to this judgment being handed down of deputies making welfare applications. And that may be because the deputy was referring it to court in the first instance because a local authority hadn't, or because a deputy thought it fell within their general authority. But even if there wasn't an application made, there was certainly, and there is always, an ongoing dispute about the extent to which a property and affairs deputy can become involved in matters relating to health and welfare. And this is the most significant decision to date that really draws that line and really establishes that the general authority of a property and affairs deputy does not extend to matters relating to health and welfare. And if steps are to be taken in relation to a health and welfare decision, the permission of the court is going to be required. Another surprising, and that's my view, development from the case was that the court determined that the general authority of a deputy does not encompass steps in contemplation of an application for an education, health and care plan, or any appeal against a decision that P is not eligible for NHS continuing healthcare. Again, they were steps routinely taken by property and affairs deputies, and that really has changed the practice of many deputies, and then steps would need to be taken to seek authority to do that. What the court went on to say is that if circumstances arise where the protection of P's interests requires action to be taken so urgently that the prior authority to litigate cannot reasonably be obtained, a deputy proceeds at risks as to cost but may make a retrospective application for authority to recover costs. That's quite a well-established principle, and certainly deputies have been applying that in practice. And last year, Ariana and I were both involved in a case where the deputy in question had urgently made a welfare application on safeguarding grounds because there was a refusal to let any person, including the deputy, have any access to P, whether indirectly or directly, and there were significant concerns about the safety of P, and that fell comfortably within the category of cases that need to be brought before the court urgently, and that the deputy's costs were secured against P's estate, as opposed to being the court determining that the usual rule in health and welfare proceedings as to costs would apply, because that's the risk when a deputy becomes involved in proceedings in the Court of Protection that are looking at or to determine matters of health and welfare. The usual order as to costs is that there is no order, unlike in proceedings relating solely to property and affairs, where the costs are recoverable from P, unless the court's asked to depart from that normal rule. So that's something deputies have to be acutely aware of before even considering taking any steps in relation to issuing about a health and welfare decision. And then finally, where a deputy wishes to instruct their own firm to carry out legal tasks, special measures are required, which we've touched on, the issue of having to ensure that full inquiries are made of alternative solicitors, and that it's clear that quotes have been obtained before solicitors are instructed in-house. So as I say, that's a really whistle-stop tour through the conclusions of ACC, and anyone that isn't either aware of the judgment or hasn't come across it yet, I would recommend reading it. As I say, I think it's set out quite easily, and we can discuss any questions you've got in relation to it at the end of this session. But one of the key factors that was identified in the judgment is the ongoing requirement in certain circumstances for a professional deputy to take steps to ensure that the care arrangements of P are authorised. And this is extremely relevant and needs to be considered by those that practice in personal injury and clinical negligence, because where you have a case where care arrangements are going to be put in place that will amount to a deprivation of a person's liberty, and the person lacks capacity to consent to those care arrangements, steps will need to be taken to authorise it. And that is not only about authorisation from the Court of Protection, but ensuring that within the claim, the cost of those proceedings on an ongoing basis are factored in. So I'm going to try and set that out in as summary terms as I can. But what Senior Judge Hilda said, which is extremely helpful, because as I say, there is a limited number, if not no, judgments on the crossover between property and affairs and health and welfare in the context of a deputy and the role of a deputy. But she said that, of course, life does not in reality divide neatly into property and affairs issues on the one hand and welfare issues on a quite separate hand. It will sometimes be the case that decisions properly made within a property and affairs authority sit alongside the need for welfare proceedings in the Court of Protection. And then she referred specifically to the case determined by Mr. Justice Charles, as he then was, that Sam was involved in, the SRK case. And she acknowledged that such a situation was considered by the then Vice President, Charles J, in the case of SRK. Just pausing there, for any of you that aren't aware of that case, it's significant in the context of what we're talking about, because P resided in a property bought with the claim from a PI claim, and had a 24-hour package of care that was paid for directly from the settlement in that claim. And the local authority made an application to the Court of Protection to authorise those care arrangements because it was said they amounted to a deprivation of his liberty. And the case was almost immediately, I think, transferred to a High Court judge to determine the issue as to whether or not, when you have care arrangements that are privately paid for, like in that scenario, and the care arrangements amount to a deprivation of a person's liberty, do they need to be authorised by the court because they're not attributable to the state? Because for there to be a deprivation of a person's liberty within Article 5, you need to establish that the person is unable to consent to their care arrangements, that they are objectively deprived of their liberty, so they're subject to continuous supervision and control, and that their care arrangements are attributable to the state. And the issue for the court in this case was, how can the care arrangements be attributable to the state when there's no state involvement, when it's a completely privately commissioned package of care, which has been happening for decades? And in that case, the court determined quite clearly that it was attributable to the state, therefore did engage Article 5 and did require the court's authorisation. And Charles J said this: he determined that it was attributable to the state because the court awards the damages, the COP, when appointing a property and affairs deputy, and the deputy or the trustees or attorney or another person to whom the damages are paid should take steps to ensure that the relevant local authority with duties to safeguard adults knows of the regime of care, and that B, if the least restrictive available care regime to best promote P's best interests creates a situation on the ground that satisfies the objective and subjective components of a deprivation of liberty, that a welfare order based on that regime of care is made by the COP. So what Her Honour Senior Judge Hilda then went on to do is agree with Mr. Justice Charles that in the first instance it falls to the local authority to take steps to authorise any deprivation of liberty, but there may be scenarios in which a deputy has to do it because a local authority may fail to act. And she said that it's clear from the SRK case that the responsibility which burdens a deputy is to ensure that such decisions as they make in the management of peace funds result in a lawful situation. And to do that, the deputy has to alert the bodies with responsibility to take appropriate action. So if there is a case where it's clear that the care arrangements that are paid for by the deputy on behalf of P amount to a deprivation of their liberty, there is very, very clear authority now that in the first instance, the deputy ought to notify the relevant public body, the local authority, and if the local authority fails to do so, will take steps to refer it to the Court of Protection. And those applications are now being routinely made by deputies. And in my experience, I think we're going to chat about some of the cases we're all involved in, the deputies then very quickly discharged as a party, because what Senior Judge Hilda acknowledged and what Mr. Justice Charles acknowledged was that in an ideal world, of course, the responsible public bodies would take immediate action to make the application and authorise the care arrangements. But that doesn't always happen. And in those steps, the deputy would have to take steps to ensure appropriate authorisation. And she clarified that in her judgment, the deputy would need to take steps to bring the need for welfare proceedings to the attention of the court. And I know that members of our team, we've all had debate about what that actually means in terms of bringing it to the attention of the court, because procedurally, what else can a deputy do other than make the application? But I have seen applications made where it's said very clearly in the supporting grounds that the deputy considers there to be a deprivation of liberty, the local authority has failed to make the application, and that the deputy would seek to be discharged as a party with the local authority substitute as the applicant once that application is made. But what's significant, in addition to the obligation of a deputy to ensure that care arrangements are authorised, is the consideration of the cost of these proceedings. And I know that's something that Tom, I think, routinely advises on, is the estimated costs of the authorisation process in the Court of Protection, because any deprivation of liberty that's authorised by the Court of Protection can only be authorised for 12 months. So that then means an application to the court every 12 months on behalf of that person. And in cases where you have a difficult family dynamic or a potential where there's going to be a dispute about the care arrangements, there may need to be consideration as to the potential costs of that going forward and the extent to which that then needs to be factored into the claim. So hopefully we'll have time to discuss some practical examples of that in the next part of the session, but that sets out, I hope, in general terms where things are as to the authority of a deputy and the steps that may need to be taken to authorise care arrangements.
Super, thank you very much, Francesca. Just making sure that we are all on the gallery, so bear with me for a second. Okay, all right, super. Well, thank you very much, Francesca, for that overview. So there's two panel questions that I want to put to all three of you. And the first one is allied to, Francesca, what you were just talking about in terms of the role of a financial deputy in welfare proceedings. And Tom, perhaps you may want to start off with this after I ask the question. But the question is this: how involved do you, and have you seen and have you experienced financial deputies get involved in welfare proceedings? I mean, there seems to me to be a clear distinction between a property and affairs deputy and a health and welfare deputy, but certainly in my experience, and we'll go into this in a bit more detail later, it seems to be a huge kind of confusion as to where the line draws.
Potentially very involved. I mean, aside from bringing the applications in the circumstances that Francesca mentioned, we've had cases where we've been introduced as a party to ongoing proceedings, because obviously the issues around potential financial options that are available to the person when future care, therapies, accommodation issues are being considered, it's very difficult for parties to consider that and present information to the court without input from the financial deputy, who potentially holds the purse strings and can advise on what financial options would be available to the client. So as with anything under the Mental Capacity Act, it really varies from case to case. And the distinction between, or the line, I should say, where the role of the deputy strays into care arrangements is often not clear. And so I think it is an important factor to consider when a PI or clinic solicitor is considering the future deputy costs and the level of involvement that will be required by the professional deputy in those proceedings.
Yeah. I mean, I've always thought that there's two kind of issues. The number one is the money, because obviously a deputy has to be obviously doing what he or she is doing based on the settlement and what's been awarded to them to properly represent P as a property and affairs deputy. But then always they need to err on the side of caution to make sure, as the previous talk was demonstrating, that if there's been a failure by a statutory body, they ought to remedy that. I mean, Ariana and Francesca, do you find, have you found other examples of when that actually, where that tension comes about and how the courts resolved it?
One of the areas where I've seen it come up, and I think Sam's rightly raising this, is, I mean, very, very often for property and affairs deputies, one of your central jobs is purchasing care on behalf of P and trying to make sure that P has P's money is being spent in a way that facilitates his or her lifestyle. That can certainly be something that's relevant within health and welfare proceedings, because it comes down to the fundamental question of what can be done for P, what are the available options, and you do need input from health and from property and affairs deputies in those scenarios. Generally, where I've seen it in health and welfare proceedings in the Court of Protection, the deputies do try to take a bit of a step back and try to give a general sense of what sort of money P has available, what the budget is. But I think often trying to respect that line between property and affairs and health and welfare, as hazy a line as it always is, but trying to defer to some extent and view those decisions as broader best interest decisions, rather than the ones that would sit on a commissioning basis alone from the deputy's perspective.
Right. I mean, that's what's always, I mean, historically vexed me, that a property and affairs deputy, for instance, using your example, is commissioning a package of care, is going to be able to, or needs to be able to determine whether that package meets that person's needs, whether it effectively does so in the future, and review it, etc. I mean, those are all health and welfare issues, aren't they, Francesca?
Absolutely. I mean, I was involved in a case yesterday where usually the judge joined the property and affairs deputy as a party to the proceedings, and directed the deputy to file evidence on what care could be provided in the community, whether or not P could purchase a property, and really unusually wants the deputy to participate in the final hearing, because the issue before the court in that case is whether or not it's in P's best interest to purchase a property and pay for a package of care in that property. And I just cannot see how the court can properly evaluate that without the involvement of the deputy. Yeah. It's a proper use of it. But then I've had experiences where the court is extremely reluctant to involve the deputy in any way. And I think that's often because the court fears there being a financial cost to P of doing that. But there has to be an overlap. There just has to be. Because as you say, Sam, to make a decision to commission a package, you have to be satisfied that package meets P's needs and is in P's best interest. And that might include consideration of the extent to which P can have contact with others in that certain place, or the extent to which P can engage in activities that they want to do. They're all decisions that on any analysis are not strictly financial decisions.
Yeah.
Well,
so,
sorry.
No, please.
Well, I was going to say, I think this sort of brings us back to some of the overall overlap issues with PI and core protection issues, because one thing that I've had raised to me recently by someone who knows far better than I do was this sort of chicken and egg issue in PI proceedings themselves, of when you're looking at what sort of package of care a person is said to need to have, it really does matter what the consideration of the person's best interest is. Because, as Francesca rightly points out, there are all sorts of different ways that you could meet a person's needs, and what you consider a need and what you consider a preference. And this is something certainly that we see on the public law side quite a lot, in terms of there are many different ways to meet a person's needs. You can meet a person's needs in a care home. You can meet a person's needs in a nicer care home. You can meet a person's needs in a supported living accommodation. You can meet a person's needs in their own house with a 24-hour package of care. Those are all meeting a person's needs. But the question, often and bluntly put, is how much money are you willing and able to spend on doing that? And when you come back into COP welfare proceedings, the first question that the Court of Protection is always going to ask is, well, what can you do? What is available? Because the COP can't magic up money, but the COP can look at different options and say, what's the best ones of the ones that that you could choose for yourself in the event that you had capacity. So I think that's probably a really tricky thing for PI practitioners, because when you're looking at what sort of care package you're saying the person requires as a result of their injury, you do have to give that consideration to best interest, which isn't always clear. You do certainly see some cases on the health and welfare side where there's a view taken that it's not in the person's best interest to be in their home with a 24-hour package of care, because that's actually really isolating for them, or it's too restrictive for them to live in their house with two people all the time.
Yeah, I mean, those are competing factors, aren't they? I mean, I wonder, before I move on to the second panel question, if I can propose this, that, I mean, say for instance, and this comes out of one of your talks, that say for instance, a bit like the SRA case, a statutory body fails to do something that they should have done, and they have an appointment of a property and affairs deputy. And that could be not authorizing the deprivation of liberty or whatever it is, that's not important. Do you think then the health and the property and affairs deputy should make an application to the Court of Protection? And if so, do you think that they can obtain their costs from doing so because there's been a failure of the statutory bodies? Tom, what do you think about that? Or have you had any experience of that?
It's a tricky one, isn't it? I think it's right for the deputy to step in and act, but the issue of costs is not clear in my mind. And I suppose going back to the sort of overall point about the involvement of the deputy in welfare proceedings, not just the challenges for the court making decisions without the input from the deputy. It's very difficult for the deputy to manage someone's finances if they're not involved and consulted around what's being considered with the welfare proceedings. The case I mentioned previously, where we've been joined as a party, we needed the information from those proceedings to consider how we're going to manage that person's finances. And so we always find these issues a real challenge, because we don't want to overstep the mark or our authority or involve ourselves where we shouldn't. And obviously there's cost implications for us if we do and we don't recover those costs. I know that the SCCO, when we submit our bills for annual deputyship, we will be scrutinising any work that they feel has strayed into the realm of welfare proceedings. But where we have been involved as a party, I think the orders that we have from those proceedings assist us in submitting those costs to the SCCO and demonstrating that we've not overstepped, that we were required, and that the Court of Protection in that particular case agreed. But then those costs obviously need to be considered as part of the PI claim, or there's a potential shortfall in the future costs of deputyship, especially if it arises frequently across a client's life, and there might be regular breakdown in care and accommodation arrangements that require further consideration from the Court of Protection.
Yeah. Have either of you ever come across a scenario where a property affairs deputy has made an application and successfully got their costs for making that application because there's been a failure of a statutory body to do something?
I have several times, but only in relation to deprivation of liberty. So where there's been so I think you're on safe ground where you're referring the matter because there's a deprivation of liberty that needs authorization. I think we've now got 2 authorities on the point. I think you're on fairly safe ground if it's an urgent matter. Anything else, I think, needs really careful consideration, but of course, really careful consideration costs money. and taking advice on that costs money. So it's really tricky. And the more that can be factored into a claim, the more that you can project in terms of what's anticipated to happen, the better. Tom, I don't know about your experience, but I would imagine that it's relatively straightforward to identify the cases that are likely to be contentious going forward in the COP against the cases that aren't. The cases where it's clear a statutory will application would be contested, or care arrangements are likely to break down routinely. Those sorts of cases, are they easier to factor into the claim, the future costs?
Yeah, I think they are. And I also think it helps, from my experience, if, I suppose there's two factors, the cases where we've been asked to provide evidence on future costs where we're not directly involved, it's really important that we've got as much of the evidence available as possible from the claim and the various experts that are instructed in that matter. But then the cases where we've sometimes provided statements on future costs where we're also acting as the deputy, the earlier we're involved in a case, that's where it's easier to start to dig underneath the family dynamics and look at the arrangements around the support if there's going to be issues and challenges in respect of that. That then makes it much easier to forecast how likely the issues are to arise in the client's lifetime and how frequently. And it's when I look at some of the statements that are produced on future deputy costs, I think that the contingency funds that are required is one of the areas that's really underestimated, because the client's life is not likely to be routine, which means that the level of deputy involvement is not routine. And so if you've got projections for ongoing years of deputyships, you need the contingency to be well stocked enough and equipped enough to deal with those fluctuating years. Because even if the deputy isn't directly involved in welfare proceedings, the fact that there's welfare proceedings going on is likely to increase the amount of work that's required from the deputy just in the day-to-day administration of the finances.
Yeah, well, I mean, that brings us very neatly to the second question that I wanted to ask, which was that how important do you think it is to consider potential court protection issues as part of the PI and Clin Neg claim, for instance, and how important is there for there to be an ongoing line of communication between the team instructed in the PI or Clin Neg proceedings and the team instructed in any concurrent or consequential court protection proceedings? What do you all think about that?
I think on the first point, I think it goes to what we were just talking about the importance of identifying the sorts of case you've got, the likely future issues that the Court of Protection is going to have to determine, and the extent to which those issues are going to be contested. In terms of the second part of the question, I have quite a lot of experience of health and welfare proceedings in the Court of Protection whilst there is an ongoing claim, and there have been difficulties about the extent to which there is communication between the parties, and it causes real issues. There's one example I hope encapsulates it, is that there's a case I'm involved in at the moment where a case was referred to the Court of Protection by a deputy because there is a deprivation of P's liberty by reason of the care arrangements that are paid for out of an interim payment. Now, the role of the Court of Protection then is to scrutinise those care arrangements, look at the decisions that have been made, why are they necessary, has the Methyl Capacity Act been followed? And in that case, there is really thin evidence as to the decision making that's been taken by the deputy, and almost no communication from the deputy with the lawyers within the welfare proceedings. It's caused delay, it's caused the deputy to be criticised within the welfare proceedings, but it's also caused issues to come up that may impact on the claim. One example is that the relevant public body, in this case is a local authority, has come on board, looked at the case and said that P is probably going to be eligible for continuing healthcare, so have a fully NHS funded package of care. And the deputy, who's also the solicitor in the PI claim, has said, you mustn't do that, it will jeopardise the claim, please don't do that. Whereas if there had been an open line of communication, that issue wouldn't have come up within the Court of Protection proceedings. There could have been a collaborative approach, and it could have been a really straightforward case for the Court of Protection to authorise. because there hasn't been that communication and there hasn't been that detailed process of identifying what P's needs are, how they can be met, and then following the best interest process. It's now quite difficult, lengthy proceedings because decisions have been taken, even decisions such as the restriction of alcohol for P, restriction of cannabis use, but no evidence as to the best interest process or why that's necessary. So I think one message that I think needs to be clear from a health and welfare perspective is that the Court of Protection does not routinely just authorise care arrangements. They are scrutinised in detail, and the Court of Protection will want an explanation as to every decision that's made, particularly if those decisions are taken against the will of P and seek to restrict P's liberty and autonomy, you know, things as fundamental as whether or not P can have an alcoholic drink or have contact with certain people in P's life. May be absolutely decisions taken in P's best interest, but it needs to be evidenced really clearly. And so in that case, it's caused delay, it's caused complications in the PI claim, and unfortunately has led to criticism within proceedings of the deputy. So that there just needs to be that ongoing line of communication. And sorry, if I make one more point, it's that the team in the health and welfare proceedings, I would hope, might be really well placed to indicate their view to the lawyers in the PI claim as to what the potential future issues are and the sorts of things that need to be factored in, rather than sort of an obstructive approach. I think it can only benefit all involved if there's collaboration and if the lawyers in the health and welfare set of proceedings are fully up to speed about where things are with the PI claim, and they would never want to take any steps that would jeopardise that claim.
And I think something I've certainly seen a couple of times is scenarios in which people have come out of PI proceedings with extraordinarily large packages of care, but actually they found them really oppressive at the end of the day. And sometimes there's often this discussion of saying, oh, well, this is what was recommended within the PI proceedings. But then you come out of it and people start to implement it on interim payments and it's just not working. And I think that sometimes, I think as Francesca rightly says, the Court of Protection will really scrutinize that. And if you have a scenario where these things are being tried out and it's not working for the person for whatever reason, then that needs to be fed back and there needs to be that conversation. I think that the flip side of it as well is in this scenario of looking at what the person actually needs. Sometimes you get care packages that don't work because it's too much. Sometimes you get care packages that work because it's not enough. And that's something I think is also really important to be feeding back into the PI proceedings to say, well, how is the person doing with the level of money that's actually being provided on the interim payment? Is that enough? Is this actually working? Or is, you have a scenario, I think Francesca's giving an example, where the person's really floundering. And, that needs to come back because you need to be able to say, we tried it at this level, we tried it on a local authority package of care, and the person got sectioned, the person was really struggling, the person was having all of these issues. And I think, as I said before, it really is this chicken and the egg question is the COP will want to approve whatever the best package of care is for the person. In the PI proceedings, you're certainly trying to achieve the best outcome that you can get, but they're not always looked at in quite the same lens. And I think that is why the communication is so key.
Yeah, I mean, I can give an example of when an overzealous insurer wanted to be part of Court of Protection proceedings because there was a claim, there was a Court of Protection proceedings where the decisions would be made about P's residents and whether they were going to be living in their own accommodation or in an institution. And because of family dynamics, it was looking unlikely that the P would be actually residing in a separate house and be residing in a care home, for instance, or a nursing home. And the cost of that is substantially less than a package of care at someone's house. And we had an insurance company who actually then wanted to become a party in the Court of Protection proceedings, and they were refused for obvious reasons. But you can flip that around and actually see how, in some cases, it may benefit personal injury proceedings and the parties, and especially the claimant's lawyers in those cases, to work with the Court of Protection case if there is one ongoing at the same time. Tom, is that something that you've had experience of?
No, not with an insurer trying to be brought in as part of Court of Protection proceedings, but it doesn't surprise me. And I suppose on the issue of communication with the PI team and starting conversations early. The opinions on capacity might change and develop as a case progresses, particularly as if there's interim payments introduced and if there's care packages and teams and therapies that have been developed. But the person whose capacity is being assessed, it might be very different when there's those additional complexities that are being considered. And so I think that's important as well. And from the cases I've seen where there's been challenges or things have potentially gone wrong, it's always been in the cases where it's been considered at a sort of very late point in a claim, and also from the sort of potential of financial abuse and safeguarding. The earlier that court protection specialists are being consulted and involved, it's often easier to try and pick up and take any necessary steps or action to protect the person against that. Yeah. And I think that's also the case, even if it's determined that the person has capacity but potentially is vulnerable and might need support through a PI trust. I know I've unfortunately seen cases where it's only really been considered once a claim's settled, and then it's very difficult to try and engage with that vulnerable person, particularly if they've got influences around them that might not want that support or protection. So the sooner it's considered, the better. And I think there's no harm in obtaining advice as the claim goes on from a court of protection practitioner, even if the initial advice is that the input isn't required at that point when they first consult the solicitor. So,
great. Well, that brings us to a natural end to this seminar. Thank you to my panel members for really insightful talks, first of all, and a really interesting debate on those two topics or two themes that we've been discussing. The presentations are available, PowerPoint presentations. So if anybody wants a copy of those, please email our marketing teams and they'll distribute them. Our contact details, should you wish to get in touch with us, are also contained on those marketing details. So thank you very much for attending. We try to field as many questions as we can, but time doesn't permit us to ask all of the questions. So apologies for those who've asked really pertinent questions that we haven't been able to answer, but we'll try to answer them on the Q&A function as later on if possible. But thank you very much for attending, and I hope today's been of interest to all of you. Thank you very much.